So last week I was working with a client on a new plan. There was a part where they wanted to do something very specific because they read somewhere online this is how it was going to work. But during my study, I recall there was a law case where this exact situation came up. It went to the court and the judge actually ruled the outcome opposite of what this couple was thinking of. Now we checked with a lawyer and it turned out that this was correct. There was such a case already. So if any of the family members give them any trouble, take their estate to court, it could have ended badly for them. Now, luckily we caught this in time, and this gave me an idea for this week's video. I want to do something different. I want to talk about cases that I came across while doing planning that when it ended up being in court, have outcomes that were contrary to what most folks are thinking about. Now, I picked 3 cases today that will cover different aspects of financial planning. We're going to go through them and also see what we can learn from this outcome. So if you like what you're watching today, make sure you comment down below and let me know that I should be making more of these. Alright, without further ado, let's dive into this week's video. Okay, so first case I want to talk about this week is Morphy Sweet, and this is going to be focusing on insurance proceeds. This is interesting because we always thought that once insurance beneficiary has been set in place, especially irrevocable, which means not even the owner can change after setting someone as irrevocable, we thought it's just set in stone, it's done. There's no more change, no one can ever argue against it. Well, this case proved that it's not totally true. So some backstory here. We have a husband here, Lawrence, who was married to first wife, Michelle Moore, and they had an insurance where Lawrence is a life insured. Upon separation, they've decided to keep the insurance and have Michelle keep paying the premium and have her as a beneficiary. So when Lawrence dies, the first wife still gets the payout. Now, of course, if we're sitting here and talking about this today, that means that didn't happen. Lawrence did not keep his promise. And he actually secretly named his new partner, Miss Sweet, as an irrevocable beneficiary on this insurance. Now, years later, Lawrence dies, and of course, Miss Moore, not knowing any better, claims the payout from the insurance, only to find out she is no longer the beneficiary for many years. What? So she goes ahead and sues Miss Sweet for the insurance proceeds. Now, this case went all the way to the Supreme Court, and in the end, the judge ruled that Miss Sweet has been enriched unjustifiably because Miss Moore was able to prove that this was the original promise. She keeps paying the premium, and she gets the insurance payout when Lawrence dies. So the court actually overruled the irrevocable beneficiary in the insurance and awarded Miss Moore $250K. So what is the lesson here? Well, first of all, we need to know that insurance beneficiary, while it is very private and most of the time very safe, it is not 100% sure thing, especially if you have blended family or complicated family situation or promises were made between different spouses, different kids. You have to be very, very careful. So instead of relying on insurance and its beneficiary, which is just supposed to be one of the many tools inside estate planning, you need to sit down with a planner and do an overall estate plan, especially if you have complicated family situation. So if you're thinking about going back some of your promises or cutting someone out from an inheritance altogether, you better ask for proper legal and planning advice, or else your heirs will find themselves in a great surprise and lots of headache and heartache and waste a lot of time and money just to go through court and maybe in the end still lose a lot of the payout. And finally, of course, if you are the payer in these kind of arrangement where you're paying for someone's insurance, hoping or expecting you will be the beneficiary, keep a very, very clear record of you paying for that policy out of an account that only you own. So if we have to go to court, it will be very easy for you to prove. Alright, so now that we're done with insurance, let's move over to the second case, and this is PCOR v. PCOR, and this is going to focus on whether parents transferring something to kids, it's a gift or in trust. So backstory is that the father has 3 kids here. One of them is a daughter with a low-paying job and also takes care of her disabled husband. Now the father is getting old and he decided to add this daughter onto the joint bank account with about $1 million inside based on financial advisor's advice to avoid probate. The father tells CRA that the money is his and he reports all the interest under his name. Now the daughter also cannot access the account without father's consent. In the father's will, he said that the estate, if he ever dies, is to go to the daughter, husband, and the children, but he did not specifically mention the bank account. Now the father dies years later, the daughter then goes ahead and then redeems everything within the account as a joint owner, so it rolls over and it belongs to her. Later on, the daughter and the husband divorce. The husband sues her for half of the money inside that joint account because he's arguing that when the wife is holding this account, it is in trust of the father. It's not really hers, so it should fall to the estate and since he's on the will, he should get half of it. Now, the wife argues back and said, no, this is actually a gift. This is actually a presumption of advancement when he added me onto the joint account. So it's actually all mine, and as a gift, it's not entitled to a split with the husband. Once again, this goes all the way to the Supreme Court. Here, the judge rules the daughter as winner, so she gets to keep everything because she has overwhelming evidence to prove that this is in fact a gift and a presumption of advancement. However, there is something very interesting in this case. So in Canada, there is an understanding that whenever there's a parent passing on to any of their assets onto their child that is no longer a minor, it is on the child's onus to prove this is a presumption of advancement. So the court is basically saying, because you're not minor, you can pretty much take care of yourself. We shouldn't assume that just because adding you on title makes this a gift and it's yours. We should always assume it is not, unless you can prove we're wrong. We kind of talked about this in the Bare Trust video we just went through, when a parent adds someone onto the joint title, but it's intended not as a gift, then it is in fact a trust. Now, like I said, it didn't matter here because the daughter could prove it anyway. But it was interesting because one of the judges on the case, Justice Abella, actually came out and specifically refute or not agreeing with this understanding. She's saying that the presumption of advancement or gift should not be just based on whether a parent decides to take care of the children or not. It should also be based on their affection and love for the children. So she doesn't agree that just because someone turning 18 and becoming an adult, this presumption of gift should stop here and become in trust. Now, this remark was actually brought up again by the same judge on another case that was similar to this, the Matson Estate versus Sater. However, in that case, there wasn't enough evidence to prove that this was a gift and not in trust. So the first takeaway is, I think in these kind of cases, even though there is already a pre-existing understanding of a presumption of gift versus trust when it comes to adult children, judge can still go ahead and disagree with this and push for their own judgment. And because of this is why I always disagree with the advice of adding your kids onto any joint account property just for the sake of bypassing probate. While saving money is great, I find that it's never justifiable to bring your kids on board and could potentially invite a lot of these legal issues. Instead, I would recommend using other tools such as power of attorney for day-to-day transaction if that's what you need, or using insurance to handle the probate cost. But if you do insist to go through that joint account or joint property route, then make sure you document very clearly whether this is a gift or in trust. Alright, so the final case we're going to be looking at is something different. It's going to be McCain v. McCain, and here we'll be looking at a record-breaking spousal support. So in here, Michael and Christine McCain has been married for 30 years. Together, they have 5 kids. Michael is the CEO of Maple Leaf Foods. Christine takes care of her 5 children and handle family/business social engagement. So she hasn't been officially working in the workforce for almost 26 years. Now, halfway through their marriage, Michael's father, Wallace McCain of McCain's Foods, came to all his children and insisted that every single one of them have a post-nup agreement with their spouse, or they might be in risk of getting disinherited. So in 1996, Christine and Michael entered into a post-nup agreement stating that she won't split any assets nor claim any spousal support should they separate. Years later, they divorce. Christine comes back and sues Michael and asks the Supreme Court of Canada to remove that section of the post-nup agreement and award her some spousal support. So here you may think, well, that's clearly not going to fly because they've signed a legit document, a contract stating she won't be asking for spousal support. And of course, that's where we're wrong, and that's why we're talking about this here, is because she actually won. Now, at the time of hearing, Christine has a monthly investment income of $10,000 from the $7 million lump sum she received upon separation. However, her monthly spending at this time is close to $120,000. On the other hand, her ex-husband, Michael, earns $800,000 per month and has a net worth of over $500 million. Now, the judge ruled in favor of Christine under 2 reasons. Number one is that the contract at that time was not fair because it was signed under duress. And number 2, Christine had no way of figuring or projecting future wealth of her husband of the time. Using the guideline based on Michael's income and net worth, the spousal support per month should come around $300,000 to $400,000. However, Judge Greer thought $175,000 per month would be sufficient for Christine's monthly spending. Now, this case has brought a lot of controversy, with some people supporting Christine, supporting the decision, good on her, and agreeing that this contract was not fair to start with. However, there's also equal amount of people saying this isn't fair because at the end, this is a contract signed by Christine, knowing full well what is the right she's giving up on. And also they were questioning whether using Michael's income and net worth as kind of one of the explanation is sufficient enough. What if Michael actually lost his job and no longer earns that much or have that much net worth, then does that suddenly make the spousal support argument not as okay? Now, personally, I have no opinion about this. I think both sides have their merits. This is definitely a well-known case within family law, and I think there's some takeaway here. Number one, this has served as a precedent of any future cases involving high-income earners, usually around the $350K per year mark. That's when the judge could potentially award a different number as per the spousal support guideline. And second of all, obviously, is having a postnup or prenup, it's simply not good enough, especially if that's all you rely on. It's not ironclad, as we can see here. What's better is if you're ever going through separation, divorce, or you're about to, better seek proper, brand new overall legal advice to have a review of the whole situation again, just to know what kind of spousal support or asset split you may be risking here. Alright, so that's basically it for this week's video. 3 cases all covering different aspects of financial planning and where it can give you trouble and what kind of takeaway we can have here. Do you like these kind of style? This is my first time trying. Let me know in the comment down below. Do you know any other cases that is popular in Canada that I should be talking about next time? Also, let me know in the comment. Now, if you like these kind of videos, I do try to upload them every 2 weeks. So make sure you like this video, subscribe to the channel, and click the bell button to get all the notifications in the future. This is Jackie Ko. I hope you found this interesting. I'll see you in the next video. Bye!